My brother said it the way you'd tell someone the dishwasher needed to be emptied. Flat, casual, like it was already done and the only thing left was for me to nod along. The house is going to sell in 30 days. I need you to sign the quit claim. I looked at him across my mother's kitchen table. The same table where she'd taught me to fold pie crust, where I'd done homework for 12 years, where we'd eaten Thanksgiving dinner every single year of my life. The coffee between my hands was still hot. I didn't throw it at him. I didn't raise my voice. I just set the mug down very carefully on the wooden surface and said, "Show me." He slid a folder across the table like he'd been waiting for that exact moment. Inside was a purchase agreement. A developer's name I didn't recognize. $214,000. And at the bottom, a line for my signature above my printed name. "Mom already signed," he said. "We just need you." I looked at my mother. She was standing at the sink with her back to both of us, rinsing a glass she'd already rinsed twice. She didn't turn around. I closed the folder. I picked up my coffee. I told him I'd think about it and drove home. I did not think about it. I pulled up the county property records website before I was even through my own front door. My name is Claire. I am 38 years old. I grew up in a pale yellow house on Sycamore Road in Denton County, Texas, on a double lot my grandfather bought in 1971. He built the house himself over 2 summers. My grandmother planted the magnolia tree in the front yard the week they moved in. My mother grew up there. My brother and I grew up there. When my father died 11 years ago, the house passed to my mother outright, the way they'd arranged it. That was not in dispute. What was in dispute, what I did not yet know was in dispute, was what had happened 14 months before my brother sat across from me at that kitchen table. The property records loaded slowly. I scrolled through the deed history the way you read something you're hoping won't say what you suspect it's going to say. Transfer in 1971. Transfer at my grandfather's death. Transfer at my father's death. And then, 14 months ago, a warranty deed transferring full ownership from my mother to my brother, Daniel Marsh, for a consideration of $10. $10. I sat in my car in my own driveway and read it 3 more times. My mother had signed the house over to my brother a year and 2 months before he asked me to sign a quitclaim so a developer could tear it down. She had been standing at that sink. She had not turned around. I called my husband, Joel. He answered on the second ring. I told him what I was looking at. He was quiet for a long moment and then he said, "What do you need from me right now?" I said, "I need you to not say anything until I figure out what I'm actually looking at." He said, "Okay, I'm here." I went inside. I made a second cup of coffee I didn't drink. I sat at the kitchen table in my own house, and I thought about the last 14 months. My mother had a mild stroke 19 months ago. Nothing catastrophic, her speech came back fully. Her movement was fine, but she spent 6 weeks in a rehabilitation facility afterward, and there had been a period, a window of maybe 3 or 4 months following that, when she was not herself. Softer. More agreeable. Less likely to push back on anything anyone suggested. I thought about how during that period my brother had started coming around more, how he'd started handling her bills, how he'd offered to take care of the paperwork when her homeowner's insurance needed to be renewed, how I'd been grateful because I was working full-time and raising 2 kids and I'd thought, finally, Daniel is stepping up. I went back to the property records. The warranty deed had been filed on a Tuesday in March. My mother had still been in physical therapy at that point. I wrote down the instrument number. I wrote down the date. I wrote down the name of the notary who had acknowledged my mother's signature. The name was Renee Calloway. I did not sleep that night. The next morning, I drove to the Denton County Clerk's office on McKinney Street. I arrived 8 minutes after they opened. The parking lot was mostly empty. I went in through the glass doors, and I walked to the records counter, and I told the woman behind the desk that I needed to pull a specific instrument and review the filed document in person. She was maybe 55, with reading glasses on a beaded chain and a no-nonsense efficiency that I found immediately reassuring. She typed in the instrument number I gave her, clicked twice, and printed the document. She slid it across the counter. I looked at my mother's signature. I had seen my mother's signature my entire life, on permission slips, on birthday cards, on the back of checks. On the closing documents, when she and my father refinanced the house in 2003, which I happened to have a copy of because I'd helped her organize her files 2 years ago. Her signature had a particular quality, the capital D in her first name, Dorothy, made a long, looping backstroke that almost doubled under itself. It was distinctive. It was hers. She'd written it 10,000 times. The signature on the warranty deed made the deed differently. The loop went forward. Small thing. Easy to miss if you weren't looking. I was looking. I asked the clerk if I could speak with someone about a potentially fraudulent filing. She looked at me over her reading glasses. Not unkindly. She said, "Let me get the recording supervisor." I waited at the counter. A man came out of the back office younger than I'd expected. Maybe mid-40s, short-sleeved button-down, county ID badge. His name was Supervisor Gerald Okafor. He shook my hand. He asked me what I was seeing. I laid the warranty deed on the counter. I laid my phone next to it. Open to a photograph of my mother's signature from the 2003 refinancing documents I'd photographed before I left the house that morning. I pointed to the capital D in both. He leaned over the counter and looked for a long time without saying anything. Then he straightened up and said, "When was the grantor's incapacity event?" I said, "She had a stroke 19 months ago. This deed was filed 14 months ago, during her recovery." He said, "Do you have documentation of the medical timeline?" I said I could have her discharge summary and rehab records by end of day. I had medical power of attorney and she'd given me access to her records. He nodded slowly. Then he picked up his phone and called someone. He turned slightly away from me while he spoke, but I caught the words title examiner and possible forgery and DPS contact. When he turned back, he said, "I need you to write down everything you just told me. Date of stroke, date of deed, what you're observing about the signature. I'm going to have someone pull the notarization record for that instrument." I asked who Renee Calloway was. He typed the name. He was quiet. Then he said, "Her notary commission expired 8 months before this document was filed." The fluorescent light above the counter buzzed once. I put both hands flat on the formica surface to keep them still. A notary whose commission had expired by 8 months had acknowledged my mother's signature on a deed transferring a $200,000 property to my brother for $10, 4 months after my mother suffered a stroke. I wrote down everything he asked me to write down. I asked him what happened next. He told me the county had an obligation to refer potential recording fraud to the district attorney's office. He told me that did not mean the DA would act, but that referral was automatic once they had documentation. He told me that separately, I should consult a real estate attorney about filing a suit to quiet title, which would cloud the property and prevent any sale until the court resolved the ownership question. I asked how long that would take. He said, "If there's a pending sale, your attorney can file for a temporary restraining order. That can happen within days." I thanked him. I shook his hand. I walked to my car. I sat in the driver's seat, and I called my mother. She answered on the third ring. I asked her if she remembered signing any paperwork about the house 14 months ago. There was a pause that went on long enough that I knew. Not because she said anything wrong, because she said nothing at all for just a half second too long before she said, "Daniel handles all of that, honey." I said, "Mom, did you sign a deed transferring the house to Daniel's name?" Another pause. Then, very quietly, he said it was for tax purposes. I closed my eyes. I said, "He told you it was for taxes." He said it would protect me, in case something happened. "Do you know how much the developer is offering to pay for the house?" Silence. "Mom, the developer is paying $214,000. And 14 months ago, Daniel put the house in his name for $10. What came out of her then was not a word. It was a sound, small and punctured, like air going out of something that had held pressure for a very long time. I told her I was handling it. I told her not to call Daniel. I told her I was going to need her to sign something for me later that week, and that before she signed anything else from anyone, ever, she was going to call me first. She said okay. She said it twice. She sounded like she had when I was 17, and she'd had to tell me my father's biopsy came back positive, like someone who had just learned that the solid ground they'd been standing on had been hollow the whole time. I called Joel from the parking lot. I told him what I'd found. He was quiet for a moment, and then he said, "Tell me what you need." I said, "I need a real estate attorney who does quiet title and fraud today, not next week." He said, "I'll start calling." By 2 that afternoon, I was sitting in the office of an attorney named Patricia Hose, a woman about 60 with a framed needlepoint behind her desk that said, "Prepare, don't panic" in burgundy thread. She read through the instrument I'd brought. She looked at the signature comparison. She reviewed the notary commission records I'd pulled from the Texas Secretary of State's website, confirming the expiration date. She asked 3 clarifying questions. Then she folded her hands on the desk. She said, "This deed has 2 independent problems. First, the notarial acknowledgement is void because the notary's commission had lapsed. Under Texas law, a void acknowledgement means the deed was never properly executed and cannot be legally recorded. which means it conveys nothing. Second, if your mother's signature is not genuine, that's fraud. Those are separate tracks, and both of them help you. I asked about the sale. She said, I'll file for a temporary restraining order tomorrow morning. Once that's in place, no title company in this state will close on that property. The sale stops until a court says otherwise. I asked how long it would hold. She said, long enough for us to file the quiet title suit and request a hearing. At the hearing, the deed gets examined. If the court agrees the notarization was defective, and it was, there's no dispute on the expiration date, the deed is void. The house never legally left your mother's name. I drove home. Joel had dinner on the table. The kids were doing homework at the counter. I sat down and ate and helped my daughter with her long division, and I did not tell anyone at that table how close we had come to something that could not have been undone. The restraining order was filed the next morning at 8:47 a.m. Daniel called me at 11:15. I let it go to voicemail. He left a message that was 6 minutes long and covered, in this order, that I was being dramatic, that he was only protecting the family's interests, that the developer's offer was going to expire, that I had always been selfish, that Mom had agreed to everything, and that if I had a problem with any of it, I should have thought about that before I was too busy with my own life to help when she needed someone. He said the last part twice. I sent the voicemail to Patricia Howes. The TRO hearing was scheduled for 11 days later. In that 11 days, I got my mother's medical records from her neurologist, which documented that in the months following her stroke, she had shown what the records called reduced executive decision-making capacity and heightened suggestibility and clinical language for what I had watched happen from the day, outside without knowing what I was seeing. I got a statement from her physical therapist who remembered her as cooperative and easily redirected during that period. I obtained a certified copy of Renee Calloway's expired notary commission directly from the Secretary of State. Patricia also got something I hadn't expected. The title company that Daniel had hired to process the sale ran a title search when they got the developer's contract. Standard procedure. What they found was the restraining order, which they were obligated to report. But the title examiner, a woman named Susan Park, who had been doing this work for 22 years, had also flagged something else. She found the notary name in their internal database. Renee Calloway had acknowledged 2 other deeds in the same county in the same 12-month window, both with the same expired commission, both involving elderly grantors, both transferring property to a single younger relative for nominal consideration. Susan Park had submitted a voluntary disclosure to the district attorney's office 3 days before our hearing. She did this, as Patricia explained it to me, because she was a professional who had seen this exact pattern before and knew what it meant. She did not know us. She had no stake in our outcome. She simply saw something that was wrong and reported it. I thought about that for a long time. The hearing was on a Thursday. My mother came. She sat beside me at the plaintiff's table in a gray cardigan with her hands folded in her lap, and when the judge asked her directly whether she had understood, at the time of signing, that she was transferring full ownership of her home to her son for $10, with no retained right of return, she said, "No, Your Honor. I did not understand that." She said it clearly. She did not look at Daniel. Daniel's attorney argued that my mother had signed voluntarily, and that the notarial defect was a technical irregularity that didn't invalidate her intent. Patricia responded that under Texas property code, a deed with a void acknowledgement is not merely voidable, it is void on its face, regardless of the party's intent, and that this principle had been affirmed by the Texas Supreme Court in cases she cited by name. She then submitted the expired commission documentation, the medical records, the therapist's statement, and the notation from Susan Park's disclosure. The judge examined the notary commission expiration date against the deed filing date. He examined the signature comparison. He read the therapist's statement. He said, "I'm going to be brief. The notarial acknowledgement on this instrument is void as a matter of law. A void acknowledgement renders the deed itself void. The property did not transfer. It remains in the name of Dorothy Marsh." He looked at Daniel's attorney. "The restraining order is converted to a preliminary injunction pending the full quiet title proceeding, which I expect to be largely a formality given what I'm looking at. And I am directing the clerk to forward the record of this proceeding to the district attorney's office for review of potential elder financial exploitation." He hit the bench with his gavel. That was it. Daniel walked out of the courtroom without speaking to me or to our mother. His attorney followed him. I watched them go through the swinging doors, and I felt something that I want to describe accurately because it mattered to me that I named it correctly. It was not satisfaction. It was not the specific pleasure of watching someone fall. It was relief. It was the feeling of a structure holding when you'd been afraid it would come down. My mother and I went to lunch at a diner 3 blocks from the courthouse. She ordered a patty melt. I ordered coffee. We sat across from each other in a vinyl booth and she looked at her hands on the tabletop for a while, and then she said, "I should have called you when he brought those papers." I said, "You should have, but he chose to use that." She said, "I kept telling myself he was trying to help." I said, "I know." We ate. We talked about my daughter's upcoming school play. We talked about the magnolia tree in the front yard, which had a branch that needed to be trimmed before it hit the gutter. She said she'd been meaning to call someone about it for 2 years. I told her I'd take care of it. In the weeks that followed, the district attorney's office opened an investigation. I was not a party to that process, and I will not speak to what it ultimately produced, except to say that Renee Calloway's 2 other deed acknowledgments were also referred for review, and that the other families involved were notified. I know this because Patricia told me. I know it because Susan Park called me once, briefly, to let me know that her disclosure had connected to a larger pattern the DA's office was now examining. I thanked her. She said, "This is what the process is supposed to do." I thought about those words for a long time after I hung up. I changed my mother's estate planning documents. I became her durable power of attorney for both finances and healthcare. We hired an elder law attorney to set up a revocable living trust with specific protections against undue influence. We added a requirement that any transfer of real property requires independent legal counsel for her, specifically not a family member's attorney, not a shared attorney, but her own, with her interests alone. She also updated her will. Daniel's name is not in it. She made that decision herself, on a clear Tuesday morning, in the office of her new attorney, with no one else present. The attorney noted in the file that she had capacity, that she was not under duress, and that she stated her wishes clearly and without hesitation. I know this because I asked, and because the attorney told me. I was not in that room. I did not need to be. The house is still on Sycamore Road. The developer's contract expired. My mother has no plans to sell. Last spring, I hired a tree service to trim the magnolia branch before it hit the gutter, and while they were working, I stood in the front yard and looked at the tree my grandmother planted in 1971, when the house was new and the neighborhood was quiet, and no one yet knew what the ground beneath it would mean to the people who came after. I do not speak to my brother. This is not a decision I made in anger. I made it the same way I made every other decision in this story, carefully, after I understood what I was actually looking at. What I was looking at was a man who had watched our mother lie still in a hospital bed and begun calculating, who had sat across from me at her kitchen table and told me to sign a paper that would have made a developer rich and left nothing for anyone but him, who had called me selfish on a voicemail while holding a deed he'd obtained for $10. Some people will read what I just wrote and think, but he's your brother. Blood. Family. You should find a way. I understand why people feel that way. I used to feel that way. What I learned not from this, but from everything that came before it that I did not name clearly enough for long enough, is that family is not a fact that overrides all other facts. It is a relationship. Relationships are built on how people choose to behave toward one another. When someone shows you, clearly and documentably, how they choose to behave, the most honest thing you can do is believe them. I believe my brother. My mother calls me on Sunday evenings. We talk for 40 minutes, sometimes longer. She told me last month that she'd signed up for a watercolor class at the community center, that she'd made a friend there named Vivian who was teaching her a particular technique for painting water. She sounded like herself, the version of herself that predates the stroke and the months after it when she was quieter and softer and more easily redirected than anyone around her should have allowed. She sounded like the woman who taught me to fold pie crust at that kitchen table. That is the part I want to end on. Not the courtroom, not the voicemail, not the deed with the wrong signature and the expired notary stamp and the $10 consideration line that told you everything you needed to know about what my brother thought our family was worth. This part, my mother on the phone on a Sunday evening, telling me about how Vivian holds the brush when she paints water and how she's been practicing at her own kitchen table with a cup of coffee going cold beside her, trying to get the light right. She said she thinks she's starting to understand it, that it takes patience, that you can't force the water to hold still, you have to work with how it moves. I told her that sounded right to me. She said, "I'll show you next time you come over." I said, "I'll be there Sunday."